The fun part about doing these videos is they're mine. I get to say whatever I want. So I get to go on a rant on occasion when I want to. So this is rant time, okay, folks? The topic I'm choosing today is a case that's going to be argued before the Wisconsin Supreme Court in October. They took a family law case. I'm really happy about that. Gives me something to talk about when I do these case law updates and put in flu and all that. This is the case you chose? I mean, give me a break. The case is called, I'll try to get this right, Pulkkila or something like that. P-U-L-K-I-L. I'm reading this, folks. P-U-L-K-K-I-L-A. It's 2018 AP 712 is the, if you want to look it up, to 2018 AP 712, if you want to look up on the Court of Appeals website. And the case involves, I think, not horribly uncommon facts in certain regards. One of the things that's real common is it requires the father, the divorce decree rather, requires the father to maintain life insurance for the benefit of the children. I think that's pretty common in all our divorce decrees. It also contained a line saying if the father failed to maintain the life insurance, the mother would have a lien against the estate for the amount that the father was supposed to maintain. Well, guess what happens? Dad remarries and he names his new wife, contrary to the terms of the MSA, as the beneficiary, and Dad dies, and the amount of his estate is like, I don't know, like $5,000, and the life insurance was supposed to maintain was $250,000. So his new wife's supposed to get the $250,000, and there's nothing left for the kids that he was supposed to maintain as beneficiaries. So the children start an action which goes to the circuit court, and they're asking for the creation of a constructive trust. This is consistent with various cases in Wisconsin that allow a constructive trust to be created for life insurance proceeds where the beneficiary was not the one that was named in the divorce decree. So you think, well, we have all these cases. Why is this case of any significance? And the reason is that the circuit court decided in its finite wisdom, I don't know, whatever, to say that by saying that the remedy was a lien against the estate, that was the sole remedy available. And even though it was only worth $5,000 as opposed to $250,000, gee, that's a shame, too bad, too sad. Fortunately, the kids appealed it because I think that was a pretty bad ruling. And it goes up to the Court of Appeals in a 2-to-1 decision. Interestingly enough, the dissent was by then Court of Appeals judge, now Supreme Court Judge Hagedorn. Get back to that in a moment. The 2-to-1 decision was to reverse the trial court. And what the Court of Appeals says is that by saying that the if father fails to maintain life insurance is ordered under the judgment, or language to that extent, that the children have a lien against the estate, it didn't mean to say that that was the exclusive remedy, and the father had violated the terms of the divorce decree, and the court had, as a court of equity, authority to do what it could to make sure that the children were made whole, and they reversed the circuit court. Judge Hagedorn dissented in the case, which I find troubling. The other part I find troubling is that the Wisconsin Supreme Court chose to grant review. I'm not sure, but I think if Judge Hagedorn was part of the Court of Appeals decision, one of the, I don't think it matters that he was in the dissent. I think if he's one of the judges who makes the decision on either side, I think he recuses himself then from the Supreme Court decision, which could create a problem because now you're to an even number of judges. And unlike most other states, we don't have a rule that the Supreme Court, when they have an even number of judges, can promote a Court of Appeals judge for a specific case in order to have an odd number and actually have a decision. So we do run the risk of a 3-3 decision in this based upon Wisconsin law, but it is what it is. Hopefully it won't be, because I just don't see this as a really complicated case, which makes me wonder why, of all the cases out there, our Supreme Court decided to grant review on this one. Because to me, it's a fairly simple thing. Dad violated a court order. And I don't see why that's difficult or complicated to understand, which is that when there's a marital settlement agreement and it's incorporated into the court's judgment, which they all are, it then becomes the order of the court. It does not say in any portion of the F&Js that we enter that the marital settlement agreement is an invitation for the parties to fulfill any portion of it that they feel in the mood for fulfilling. Now, that's not what it says. It says this is made the order of the court. And maybe I'm an old timer, but I think orders should have some meaning, and that people ought to know that if they violate it, there are going to be some ramifications. Dad obviously is dead, or it wouldn't become the issue, but the point is that the children are the innocent victims of this because the life insurance was to have been maintained for their benefit. So there basically comes two choices, and only two choices. Either Dad's violation of the order is meaningless because of certain language in there, and it doesn't say sole remedy. It just says that it's a remedy that the children can have. But absent the additional potential remedy of a constructive trust, then the second wife gets a windfall in violation of a court order and the children get nothing. Or the court says, you know what, court orders have a meaning, and our message to anybody out there who's required to maintain life insurance is that we are ordering you to do it. We're not asking and saying nicely, no please with a cherry on top and sugar or whatever. It is a court order, and if you don't do it, we're going to find a way to have your estate or the life insurance proceeds comply with the court order, and family courts, as courts of equity, can find a way to do the right thing, and this is in the statute, to enforce their own orders. So that brings up the question of why the Supreme Court found this case necessary in order to grant review. And it worries me a bit, because to me this is a simple one. This is one where the Supreme Court ought to be 6-0 and say that the Court of Appeals got it right. And maybe if you want to decide this case, and Supreme Court can always change its mind and find that they granted review improvidently and let the Court of Appeals decision stand, that would be fine. Maybe order it published. It is, at the moment, a citable but unpublished decision. It's an authored opinion, which means it can be cited for its persuasive but not precedential value. So if the Supreme Court wants to say, hey, let's just let that stand, maybe order it published, if they can do that, that would be fine. Otherwise, how about a real short decision? The majority of the Court of Appeals got it right. Trial court, we don't know what you were thinking. If there's a court order, people have to comply with it. We mean it, do it, and if you don't, we're going to find a way to bring your estate or whatever we can into compliance to make sure court orders are complied with. Makes it easier for us as lawyers too, because let's face it, we occasionally have clients who want to play fast and loose with court orders, and they sometimes push the envelope and push the edge. Of course, as lawyers, we always say, oh no, you can't do it. There's a court order, you have to follow it. It'd be really nice to tell them that there'll be ramifications if they don't, and also that if there are court orders, the courts really, really mean them, and they expect them to be enforced. Friendly reminder to subscribe to Wisconsin Family Law Case Finder. Subscription information is on screen for you. We have over 1,600 family law cases in Wisconsin, many cases from out of state, organized into 135 different family law subject areas. You can search by the word, search by the area, search by the case. It's an outstanding resource, and if you practice family law in Wisconsin, you ought to subscribe to it.